Hi everyone, we welcome you back to our channel. This is Legal Mindset at the bar, and today we are handling constitutional history. And in the house, we have got chance to invite a senior counsel, a lecturer, a lawyer, and an examiner. So you are with the right person. We are going to see how to answer certain areas in the constitutional history. Though it is technical and it is somehow wide, by the end of this session, you will have learned and you will have got some message. So, Cancer, I beg you to introduce yourself.
All right, thank you. You're welcome. I welcome every viewer, everyone watching and listening. My name is Council Amoit Grace Federal, lecturer, KIU, an advocate, and an examiner as that. And I hope by the end of this session it will be as more productive and you benefit a lot from what we have to share with you.
Thank you very much, Council. By today, a number of universities are doing their exams. Some are close to doing their exams. And in this period, what our viewers expect is how to answer. So, it is true that if a person has content, is it true that if a person has content, it is irrelevant to them when they do not know how how to lay it down on the examination paper? All for you, you are after content. What does the student know? All, how has the student provided their content?
Well, when you talk of content, not every content is relevant. Okay? So when we are marking or when you're examining, we look for the relevant content that you have and how do you display or portray this content. Now that's how do you answer your exam. Because when you look at the course unit, it's principles of constitutional law 1, much as it talks about the history of Uganda. Now, the history of Uganda cannot entirely be summarized in 3 hours of the exam, okay? So we look for that relevant content based on the question that has been asked. We do not require you to write all the history that you've read, all the history you've watched in movies or documentaries, but go straight to the point, answer the question that has been posed to you. So it's not true that all we are looking for is content, but is the content that you're giving the examiner relevant, or are you simply reproducing the history that you read in certain textbooks or that you watched in documentaries? So the relevance of the content matters.
Thank you very much, Council, for that advice. Now, I beg to take us through certain areas which are more examinable, like the Buganda Agreement, the orders in Council, the 1902 and 1920 specifically. We shall look at the Repugnant clause and the reception clause. So, if a question comes on Buganda Agreement, is it true that, because I've had a number of fellow students saying that if a question comes on Buganda Agreement, after all your discussion, you should relate it to the 1995 Constitution. And again, are you supposed to write the articles of Buganda Agreement in full? Are you supposed to put a heap of cases? So, if a question comes, just give us a general overview before I give a question for you to help us to handle. How can a student attempt it in any way?
Okay, so to begin with, when you're faced with a question regarding the Buganda Agreement, one thing that you should know is that time is of essence in an exam. You have 3 hours of an exam, and most likely you are supposed to attempt 4 questions. And the presumption is the allocation of the 3 hours is that each question is allocated for 45 marks, rather 45 minutes. So those 45 minutes, it's not true that you have to reproduce the entire clauses of the Buganda Agreement as they are. They are quite lengthy and very long. You may not have the time. Nonetheless, you may not recall exactly what each clause provides for. So being that we are human as well, and we've also been students at some point, what I would encourage is learn how to paraphrase those clauses without necessarily losing the meaning of each clause. For instance, if let's say you are attempting clause 1 of the Uganda argument, which ideally talked about the demarcation of boundaries, and the original clause in the Uganda agreement is detailed in a way that it gives us or tells us how these boundaries were directed, the names of some of the regions that were formed. So, being that in the exam you may not be able to recall word for word what that argument provides, so we can simply allow you to paraphrase by simply stating that clause 1 of the Uganda argument talks about demarcation of boundaries. If maybe you're able to recall how those boundaries were named, then you can go ahead and tell us that the boundaries were demarcated as follows, and then you give us how those demarcations were made. Then the issue regarding the cases, you do not need a heap of cases like you had stated. One case is enough for, if you're able to recall at least a case for each clause, then one case is enough. However, that does not stop you from reproducing certain cases, because you may find that along the way, one case can help you to understand or clearly elaborate on about 2 or 3 clauses in the agreement. So you can use the same case for as many clauses as it explains, as long as it is relevant to your point that you're trying to put across. So no, you don't need a heap of cases.
Thank you very much, Council. And what I've learned from the discussion you have just posed is that a student can paraphrase an article of Buganda agreement, so as long as it does not lose its relevance.
Yes.
So the student must not phrase it in such a way that it will lose its relevance. They have to keep the original article in their head. So let me pose 2 questions, 2 different questions. When a question comes and says that the 1900 Buganda Agreement is one of the 1900 Buganda Agreement led to constitutional development of Uganda. Discuss. And another one comes and says that discuss the impact of the 1900 Buganda Agreement. And it stops from there. Those 2 questions appear different because the first one said that the 1900 Buganda Agreement, was of an impact to Uganda. But the other one, the second one said the 1900 Buganda Agreement discussed the impact of the 1900 Buganda Agreement. The first one had Uganda, the last one never had Uganda. So if a question comes in such a way, you first help us. All in all, what does a student have to put by the end of their discussion?
So, ideally speaking, they appear to be 2 questions, but it is the same question, simply twisted and phrased in different ways. You know, we being examiners, you do not have to reproduce the same question this year and reproduce it the same way next year, the other year. So you find simpler ways of how to twist it around. By one saying, this year you could say that define or discuss the implication of Uganda agreement or the impact it had towards the constitutional development of Uganda, but all of it we are looking at how it impacted the constitutional development of Uganda. Now, when you are to address such a question, one, when you talk about the implication or the impact, that is the same one. It means how has the Buganda agreement influenced on the development of constitutional law in Uganda or the constitutional state of Uganda. When you're approaching such a question, what the examiner simply requires you to understand or to portray, show how the historic events of signing the Buganda agreement, together with the clauses in that agreement, how did they contribute to the current constitutional state that we have in Uganda? When you talk of the constitutional state of Uganda, that is the independent Uganda.
Yes.
In other words, post-independence, how did that Uganda agreement contribute towards the independent Uganda that we enjoy today, towards the current constitution that we enjoy today, and everything underlining it. A clear analysis of the clauses in that Uganda agreement, you find that almost all of them, if not all of them, contributed greatly to the current constitution of Uganda that we have today, and also to the later events that led to the independence of Uganda. So when we are addressing that question, simply, we are looking for your analysis as a constitutional law student. Are you able to apply the history of Uganda, the process that Uganda went through right from colonialism? Are you able to show the impact that these colonialists had towards the constitutional state in Uganda that we have today? An example I could give you starting with clause 1 of the Uganda agreement. For instance, when you talk about demarcation of boundaries in Buganda.
Uganda agreement.
Exactly. The immediate implication of that would be that this influenced the later subdivisions or demarcations or boundaries that we enjoy in Uganda today. The districts that we have in Uganda today are not what we had in 1900, but the idea that the colonialists came with of subdividing Uganda into sub-regions or into the territories that we had. The main rationale for that was simply to solve issues of administration, to make administration of the protectorate at that time very easier. And it is the same ideology that even our current Uganda or our current government has still employed today. Reason being, several districts have been demarcated, and some districts are still being demarcated. The main rationale for that is once you break down the entire region into sub-regions or smaller districts, you're able to reach even the last person down in terms of service delivery, meaning it makes administration of the country very easy. So that ideology that was brought to us by the colonialists when signing the Buganda Agreement, the impact of that is that we are still using the same even up to today. So when you're answering that, after you giving the examiner what clause 1 of the agreement provided for, show the rationale, which we have said it was to make administration of the protectorate easier, and then now give us the implication, since the question is asking for the implication, which could also be the significance. How did that impact? Now bringing how has it impacted the constitutional state? That is what we call the constitutional development of Uganda. And then, of course, when we have to look at applicability and implications, you cannot go without saying you have to get the applicability from case law. Meaning, if you have a case to that effect, apply it, use it at that stage, and then conclude.
So, at that juncture, I have two questions to pose.
Okay.
One is about how to apply the cases, and another one is what language should the student use when linking the article of Buganda Agreement, the clause of Buganda Agreement, to the current Constitution 1995. Then again,
I didn't get your point with
my point
regards
is,
to the cases.
the point of the cases is that should the student just lay down the principle in the case. So, for example, you told us about the case of Kazaraine versus the Ruchifu, where Kazaraine started the campaign in Bunyoro, refusing the people of Bunyoro to pay taxes to the Baganda after the demarcation of boundaries. And he was brought to the Ruchifu. Then the Ruchifu held that the demarcation, the jurisdiction of the Kingdom of Buganda was as far as the boundaries. And the issue was, what is the jurisdiction of the Ruchifu? So, should the student just bring in the principle that in Joseph Kazaraine versus the Ruchifu, court held that the jurisdiction of the Ruchifu was as far as the boundaries of the Kingdom of Uganda. Council enlighten us on that, because I see it is an area where we can get good marks.
So when you're discussing the cases in an exam, one thing you should have at the back of your mind is that if you have read the entire case, most of these cases discuss or talk about several principles.
Yes.
However, you do not need to reflect or to reproduce all the principles in that case. Focus or point out the principle relating to your point that you're trying to put across. An example, if you are looking at Joseph Kazarain versus Aluchiku, it talked about a lot of things. But since you are attempting or explaining Article 1
Yes.
of the Buganda Agreement, which talked about demarcations, restrict yourself to the points of principles in Joseph Kazaraine that bring out the issue of
Demarcation.
implication of demarcation of a protectorate. When Joseph Kazaraine incited the people of Europe not to remit taxes, ascertaining or claiming that the jurisdiction of Uganda did not go as far as those areas. That goes to show you the implication of demarcation of this boundary. It restricted the expansion tendencies of Buganda, meaning Buganda was being restricted to only focus or collect revenue from its boundaries. That is the implication of demarcation of boundaries. So you restrict Joseph Kazaraini to the points bringing out demarcation of boundaries. You can omit the others and the like, but focus on that principle. That is if you are using that case to elaborate on clause 1 of the Buganda Agreement. Now, when you are attempting another clause, and you feel Joseph Kazarene still brings out the principle in another clause, then also point out the principles, the other principles in Kazarene that discuss that clause that you are trying to put across. You don't need to reproduce the entire clause, facts, issues, holding, and so you don't have that time in the exam. Like I told you, 45 minutes for each question.
So the other question was, what kind of language should we use? Should we be very very keen or very direct that Article 1, Clause 1 of the 1900 Uganda Agreement led to the creation of Article 177 of 1995 Constitution, which talks about creation of districts? Should we be very sure all will be presumptive?
When you talk of
So the question is that if a student is approaching and linking the 1900 Uganda Agreement to the current Constitution 1995, should they use a speculative language, or they be sure that Article 1 led to Article 157?
okay. So, to me, I would suggest, what I normally advise students is that since these are historical events that you're reporting about, okay, and the events that happened in real life, we cannot speculate history. History actually did happen. So what I would advise is be certain, because when you say could have, may have, or might, to me, if I'm the one marking, it goes to show me that you are not certain. When you look at the literal meaning of the word might, you are not certain. It goes to show probability. But when you say, well, the proper word I would encourage are or would be that Article 1 of the Buganda Agreement influenced or impacted the framers of the 1995 Constitution in regards to framing Article 177 or 78 of the current 1995 Constitution. In other words, it goes to show that the framers of the Constitution, the current Constitution, had at the back of their mind the history of the Buganda Agreement. Hence, that influenced them to enact the current Constitution. Whereas when you say might have,
Perhaps.
exactly, you are not sure. Yet the current Constitution 1995 is also there, so you cannot speculate what is already in reality.
Thank you very much, Council. So we have seen the Buganda Agreement, and I remember very well, we started our discussion, we posed certain questions, and you told us that the questions are just twisted. They are the same. So, do you mean that if a question comes of Buganda Agreement, it is a must that the student must reflect it in the 1995 Constitution?
Well, I cannot really commit myself and say must, because depending on what the question has asked or what the examiner requires, some examiners may simply examine you to see if you have an upper appreciation of the historical events leading to the signing of the Buganda Agreement, whereas some or most of the questions I've come across require you to show your knowledge of the Buganda Agreement towards or how it has contributed to the current constitutional development of Uganda. So I cannot commit myself and say it must always refer to the 1995 constitution. It depends on how the question is set. But in most cases, for most of the questions that we've been setting, we want to examine and see whether the students appreciate the history that happened in the past and how it has impacted on the current constitutional state. But it's not always a must.
Okay, thank you very much, Council. Unless otherwise, by now, a student knows what to do, whether when the question of Buganda Agreement is brought to their attention. Now, my worry is on the 1902 and the 1920 orders in council, because they are relatively similar in connecting them to the 1995 constitution. But we have very popular clauses under the orders in council. For example, the Repugnant clause. I beg you to enlighten us about the Repugnant clause. How should a student treat themselves when they reach a paper and they find a question on the Repugnant clause?
Okay, so unfortunately, you haven't given me a sample question. Maybe you want me to talk about the repugnance clause in general.
So you can enlighten us what nature of questions can be asked, the scope of that, because we are in the period of exams. What should we know about it?
Okay, so when we are talking about the repugnance clause, one, the student must have read the entire 1902 order in council and know what section in the 1902 order in council provides for the repugnance clause. Most of the time, students tend to confuse what section in the order in council provides for the repugnance clause. You find some citing section 15, and then some will cite for section 20. That goes to show that the student has not given time to read the clauses in the repugnance clause, and some get these mistakes from handouts. Okay, so when you're discussing the repugnance clause, most of the popular questions talking about the repugnance clause require you to show the justifiability of the repugnance clause. In other words, was the repugnance clause necessary in the order in council? And then two, some of the questions may ask you to show whether that repugnance clause in the order in council 1902 is still relevant to the current constitutional laws or developments that we have today. Now, when approaching such a question, usually what we examine students on is an understanding of what the white man, the colonialists, intended or aimed at by inserting the repugnance clause in the order in council. Maybe just to refresh your memories, the repugnance clause simply talks about cases civil and criminal in nature where non-natives and natives, the natives were involved. The courts of laws were allowed to apply the customary laws on condition or provided that they were not repugnant to natural justice and morals and so on, if you have read the repugnance clause. So, when examining given the repugnance clause, we expect the student one first discuss and show us the aim of the repugnance clause. Why was it inserted there?
Yes.
This is a clause that recognizes the customary practices or norms of the natives during colonial administration. However, those customary practices were subjected to a certain condition in that they did not have to violate principles of natural justice and good conscience. But the trick about the repugnance clause is that the test of that repugnance was subjective. What do we mean? It was tested based on the understandings of the white man. And this is a white man who did not appreciate the culture, practices, or the customary norms that we had in place prior to the coming of the colonialists. Now, if you have that at the back of your mind, and after giving us that detailed introduction, as a proper student ought to have read some of the ancient cases that showed how this repugnancy clause actually worked. Some of the examples, the popular examples that students normally tend to recite are R versus Amkeo. We have Gwao bin Kilimo versus Kisunda bin Ifuti. We have Mwenge versus Migade, and so on. Now, a proper reading of these cases, you go to see that they have an aspect of customary law coming into quotation in the eyes of the white man, meaning that the white man being the white judicial officers we had at that time. So the white man was subjected to interpret the applicability of some of these cultural practices we had in Africa according to his own understanding of how he viewed our customary practices, meaning that whatever customary practices we had in our societies or that were applicable, bearing in mind that before the coming of the colonialists, we did not have all the laws we have in force today. So our society was entirely governed by customary laws and practices, which were normal to us. But when the white man came, he viewed some of our practices as unnatural, mean, and so on and so forth, barbaric. Okay, so he decided to expunge some of those customary practices. An example that we can have in rather R versus Amkeo is the issue of, what was the issue, if you may remind me?
The case much
So that I know I'm
about,
not discussing this earlier.
the bride price.
Yes, payment of bride price.
Yes.
According to the white man, he deemed that as wife purchase because back in their country, in the UK, they do not pay that bride price. And according to him, in that case, Justice Hamilton understood or defined the customary laws in Uganda in terms of contract law, that marriage is a contract between man and woman. So the issue of bride price coming in is consideration. However, the woman does not have free will to consent. So when the man pays the bride price, automatically, according to Hamilton, the woman loses their consent. So after analyzing one or two, usually I advise my student to at least analyze 3 cases of the ancient cases I've cited, okay? And then when you move on to the other side of whether the repugnance clause was justified or whether it is still relevant in our society today, that is when now we look at post-independence and post the current 1995 constitution. Does that repugnance clause still hold water? Is it still relevant today? And when you're discussing that element, one, you have to show us that it survived. In other words, with Uganda attaining independence, we did not lose the repugnance clause, it remained in place. And where do we trace it from? To begin with, in the Judicature Act, when you read around your sections 15 of the Revised Judicature Act, it will clearly show you that the high courts are empowered or allowed to apply customary laws, provided they are not repugnant to natural justice. Now, this Judicature Act came in much later, after the colonialists, through the reception clause, the laws that we received from the UK. That is how we received the Judicature Act, and it saved the repugnance clause. 2, in your constitution, the current 1995 constitution, Article 2. It also shows us how the repugnance clause survived. In other words, the constitution is the supreme law of the land, and any other laws that are repugnant to or inconsistent with the constitution are null and void. So the current customary practices that we have today are still subjected to that test of repugnance, whether they violate natural justice or not. An example could be the issue of female genital mutilation. This is a customary practice that has lived on for very many years. However, when you put it to the test according to the principles of natural justice, when you talk about natural justice, these are natural morals based on humanity. Is it humane for female genital mutilation to be conducted? The answer is no. So when we find those customary practices violating levels of humanity before the eyes of a reasonable man, reasonable thinking man in society, then we can say that that practice or that customary norm is actually repugnant because it violates natural justice.
Justice.
So when you're looking at the other side of whether the repugnance clause indeed is justifiable or if it survived, you now have to give the examiner some of the, I would call them recent cases or cases that transpired after the 1995 Constitution, which showed some of those customary practices being interpreted as repugnant. One of them could be Bruno Chihuahua versus Ivan Serunkuma. I hope those viewing have been able to read and understand Bruno Chihuahua. And then the other could be Best Kemigisha versus Mabel Kumontale. We have Law Advocacy for Women versus Uganda, and so many that I do not want to exhaust as of now. So, upon you discussing and showing how the repugnance clause has survived or whether it is justifiable, then you have to give your standpoint as a student answering the exam, whether, in your opinion, the repugnancy clause is still relevant or not. That is an opinionated question. It is two-sided. Whichever side you take, you must be able to support it or back it up with evidence and certain cases. And then you conclude.
Thank you very much, Council, for such a quality discussion. And I know it is of more use to us, especially our brothers and sisters in their first semester, 1-1. So, I thank you for honoring our invitation.
You're welcome.
We have learned about the Buganda Agreement, the order in council, specifically the Repugnant clause. Thank you very much, Council. This is
welcome.
Legal Mindset at the bar.
Okay, I must commend you for the good work you're doing, and I hope that this is more productive to the listeners, to our viewers, and to our students at large. Feel free to interact in the comment section, ask any questions that you wish, and we shall be able to address them as of when we can. Thank you.